The case management system flagged 17 shadow codes assigned to my active files at 3:47 a.m. on a Tuesday when the office was supposedly empty. I'm Casper Blackstone, 42 years old, transportation law partner at our consumer rights firm here in Fresno. 20 years of practice taught me that anomalies in legal databases don't happen by accident. Someone had been systematically creating duplicate tracking numbers for my major arbitration cases, each one triggering conflict of interest alarms in our ethics monitoring software. The discovery came during my routine monthly audit of billable hours. Our firm's case management platform, LegalTrack Pro, had been sending automated alerts to my secondary email account for 3 weeks. I'd been too buried in depositions for the Henderson trucking accident case to notice them until now. Each shadow code appeared linked to legitimate case files I was actively handling. The Morrison wrongful termination matter, the Chen product liability suit, the Williams transportation injury claim. All high-value cases with substantial settlement potential. All cases where I'd been working closely with our lateral recruiting director, Garrett Timberlake, who'd joined the partnership 18 months ago. I pulled up the access logs. The shadow codes had been created during off hours, always between midnight and 4 a.m. The user credentials showed my login information, but I had been home asleep during every single timestamp. Someone had been using my access to create parallel case tracking systems that would trigger ethics violations if discovered during a state bar audit. The pattern was sophisticated. Each shadow code contained modified client intake information, altered retainer amounts, and duplicate billing entries that would make it appear I was double charging clients or creating conflicts with opposing counsel. If reported to the California State Bar, these violations would result in immediate suspension and potential criminal charges for fraud. I printed the access logs and locked them in my desk drawer. The office felt different now, like someone had been watching my every move for months. Garrett had recommended our current case management system when he arrived. He'd also insisted on handling all the technical training sessions personally. My phone buzzed with another LegalTrack Pro alert. Shadow Code 18 had just been created for the Patterson class action lawsuit I'd filed yesterday. The timestamp showed 4:23 a.m. I checked my watch. It was 4:24 a.m. Someone was in the building right now. I grabbed my keys and headed for the stairwell. The elevator would announce my presence with its mechanical hum. Our building's security system logged keycard access, but I knew the emergency stairs had a faulty sensor on the 3rd floor. Garrett had mentioned it during a partner meeting last month, suggesting we delay repairs to save on maintenance costs. The irony wasn't lost on me now. I'd trusted Garrett Timberlake completely when he joined our consumer rights practice. His credentials were impeccable. 15 years at a prestigious San Francisco firm, specializing in employment law and class action litigation. He'd brought 3 major clients with him, including the Patterson automotive defect case that was now worth $12 million in potential settlements. They guided me through my first major arbitration against Pacific Transport Industries. Garrett had insisted on handling all the case documentation personally, claiming his experience with transportation law would strengthen our position. I'd been grateful for the mentorship. The arbitration resulted in a $2.8 million settlement for our client, the largest in our firm's history. But Garrett had also been present during every strategy session, every client meeting, every document review. He'd recommended upgrading our case management system to LegalTrack Pro, claiming it would streamline our workflow and improve billing accuracy. The software cost $43,000 to implement, but Garrett assured the partners it would pay for itself within 6 months. I reached the 3rd floor and slipped through the stairwell door. The hallway was dark except for the emergency lighting. Garrett's office was at the far, next to the server room that housed our digital case files. A thin line of light showed beneath his door. The access logs I'd reviewed showed a pattern spanning 8 months. Every major case I'd handled had been assigned shadow codes within 48 hours of filing. The Morrison wrongful termination case shadow code created January 15th at 2:17 a.m. The Chen product liability suit shadow code created February 3rd at 1:44 a.m. The Williams transportation injury claim shadow code created March 8th at 3:22 a.m. Each shadow code contained subtle alterations to our original case files. Client retainer amounts inflated by 15 to 20%. Billing entries duplicated with different date stamps. Conflict check documentation modified to suggest I'd failed to identify opposing counsel relationships. The modifications were sophisticated enough to pass casual review but damaging enough to trigger ethics violations during a formal audit. I moved closer to Garrett's office. Through the frosted glass, I could see him hunched over his computer, typing rapidly. Multiple monitors displayed what appeared to be case management screens. I recognized the LegalTrack Pro interface on his primary monitor, but the secondary screen showed something different, a database I didn't recognize. My phone vibrated with another alert. Shadow Code 19 had just been created for the Patterson class action. I watched Garrett's fingers move across his keyboard, entering data that would make it appear I'd violated conflict of interest rules by representing competing plaintiffs in the automotive defect litigation. The realization hit me like a physical blow. Garrett wasn't just creating shadow codes to trigger ethics violations. He was systematically building a case file that would destroy my legal career while positioning himself to take over my client relationships. Every major settlement I'd negotiated, every successful arbitration I'd completed, every client relationship I'd built over 12 years of practice, all of it would transfer to him once the California State Bar suspended my license. I pulled out my phone and started recording video through the glass. Garrett's computer screen was clearly visible, showing him modifying client intake forms for the Patterson case. He changed the retainer amount from $75,000 to $95,000. Then duplicated the billing entry with yesterday's date stamp. The modifications would make it appear I'd been overcharging clients and creating false billing records. But Garrett made one crucial mistake. He'd been so focused on creating shadow codes for my active cases that he'd failed to notice the automated audit trail LegalTrack Pro generated for all user activities. Every keystroke, every file modification, every login session was logged with precise timestamps and user credentials. The system he'd recommended to enhance our firm's efficiency had been documenting his betrayal in meticulous detail. I had enough to expose him, but I needed to understand the full scope of his scheme. How many cases had he compromised? How many clients were at risk? How many other attorneys in our firm had been targeted? I backed away from his office and returned to the stairwell. My hands were shaking as I climbed back to the 5th floor. The magnitude of Garrett's betrayal was staggering. He'd spent 18 months infiltrating our practice, gaining our trust, learning our systems, and systematically sabotaging our most valuable cases. Back in my office, I accessed the LegalTrack Pro administrative panel using my senior partner credentials. The user activity logs revealed the true extent of Garrett's operation. He'd created shadow codes for 47 different cases across 6 attorneys in our firm. The total value of compromise settlements exceeded $38 million. But the most damaging discovery was yet to come. Garrett had been forwarding copies of our confidential case files to an external email address registered to Blackwood and Associates, a competing firm in Sacramento. Every strategy memo, every settlement negotiation, every piece of privileged client communication had been systematically leaked to our competitors for the past 8 months. The betrayal wasn't just about destroying my career. Garrett Timberlake had been conducting corporate espionage on behalf of a rival firm, using his position as our lateral recruiting director to steal our most valuable intellectual property and client relationships. I printed every access log, every shadow code report, every email notification, the filled 3 banker's boxes by dawn. As I locked the documents in my office safe, I realized Garrett would be arriving for work in less than 2 hours, completely unaware that his carefully constructed scheme had been exposed. The confrontation would have to wait until I could present the 2 our managing partners, but I knew one thing with absolute certainty. Garrett Timberlake's legal career was about to, and mine was about to be saved by the very system he'd used to try to destroy me. The emergency partners meeting convened at 7:30 that morning in our main conference room. I'd called Charlotte Timberlake, our managing partner, at 6 a.m. with a simple message. We had a security breach that required immediate attention. Charlotte arrived with Garrett Whitmore, our senior litigation partner, and Charlotte Blackwood, who handled our firm's compliance matters. I spread the across the mahogany table like a prosecutor presenting a murder case. 3 bankers' boxes of printed logs, shadow code reports, and email forwards painted an undeniable picture of systematic betrayal. Garrett Timberlake has been conducting corporate espionage for 18 months, I began, my voice steady despite the gravity of the situation. He's compromised 47 cases worth $38 million in potential settlements. Charlotte Timberlake's face went pale as she reviewed the LegalTrack Pro access logs. These timestamps show he was accessing files at 2 a.m., 3 a.m., cases he had no legitimate reason to review. Garrett Whitmore examined the shadow code reports with the methodical precision of a seasoned litigator. This is sophisticated. He understood our case management system better than most of our senior associates. The most damaging was the email forwarding logs. Every confidential document, every settlement strategy, every client communication had been systematically transmitted to Blackwood and Associates in Sacramento. Our competitor had been receiving our playbook in real time for 8 months. "We need to contact the State Bar immediately," Charlotte Blackwood advised. "This constitutes multiple violations of professional conduct rules, client confidentiality breaches, conflict of interest violations, and potential criminal fraud." At 8:15, Garrett Timberlake arrived for what he believed would be a normal workday. Charlotte Timberlake intercepted him at the elevator and escorted him directly to the conference room. His confident smile vanished the moment he saw the spread across the table. "Garrett, we need to discuss some irregularities in our case management system," Charlotte began diplomatically. I watched his face as she presented the shadow code reports. His eyes darted between the documents, calculating, searching for an explanation that wouldn't exist. When she showed him the email forwarding logs, his shoulders sagged in defeat. "I can explain," he said quietly. "Please do," Charlotte Timberlake replied. Garrett's confession unfolded over the next 40 minutes. Blackwood and Associates had recruited him specifically to infiltrate our firm. They'd offered him a partnership track and a $200,000 signing bonus in exchange for inside information on our major cases. The shadow codes were his method of tracking which files he'd already compromised. They wanted to know our settlement strategies, our client relationships, our case valuations, he admitted. I never intended for it to go this far. Charlotte Blackwood was already drafting our State Bar complaint as Garrett spoke. The violations were extensive. Business and Professions Code, Section 6106 for moral turpitude, Rule 1.6 for confidentiality breaches, and Rule 1.7 for conflict of interest violations. By 10 a.m., we'd contacted the Judicial Conduct Review Commission. Trust account investigator James Anderson arrived that afternoon to begin his formal investigation. His team would need to examine every case file Garrett had accessed, interview affected clients, and calculate the full extent of damages to our practice. The confrontation with our clients began immediately. I spent the next 3 days calling every affected client personally. Mrs. Rodriguez, whose workplace injury case had been compromised, was devastated to learn that opposing counsel had known our settlement strategy for months. The Chen family's product liability case had stalled because our competitors knew exactly how much we were willing to accept. How do we rebuild trust after something like this? Charlotte Timberlake asked during our crisis management meeting. The answer came through transparency and accountability. We disclosed the breach to every affected client, offered to withdraw from cases where conflicts existed, and provided detailed explanations of how we planned to prevent future security breaches. James Anderson's investigation revealed the full scope of Garrett's operation. He'd stolen client files worth $42 million in potential settlements. His access to our LegalTrack Pro system had been used to download confidential documents on 237 occasions. This supported both civil and criminal charges. The State Bar's disciplinary proceedings moved swiftly. Garrett Timberlake was suspended from practice pending the completion of the investigation. Blackwood and Associates faced their own disciplinary review for knowingly receiving stolen confidential information. 3 weeks after the initial discovery, criminal charges were filed. The district attorney's office charged Garrett with commercial burglary, computer fraud, and violation of fiduciary duty. Each count carried potential felony penalties. Our firm implemented new security protocols immediately. 2-factor authentication for all case management access. Quarterly security audits. Mandatory ethics training focused on identifying and preventing internal threats. The civil litigation began in earnest. We filed suit against both Garrett Timberlake and Blackwood and Associates for damages exceeding $15 million. Our clients filed their own malpractice claims, which our insurance carrier settled for undisclosed amounts. But the most satisfying moment came during Garrett's criminal sentencing hearing. Judge Patricia Morrison sentenced him to 18 months in state prison and ordered full restitution to our firm and affected clients. His law license was permanently revoked. Mr. Timberlake violated the most fundamental trust that exists in our legal system, Judge Morrison stated. The attorney-client privilege is sacred, and your systematic betrayal of that trust warrants the maximum penalty under law. As Garrett was led away in handcuffs, I felt no satisfaction, only relief that justice had been served. Our firm had survived, our clients had been protected, and the legal system had held a betrayer accountable for his crimes. The investigation had also revealed something unexpected. Garrett's operation had helped us identify security vulnerabilities that other firms were experiencing. I began consulting with the State Bar's Ethics Committee to develop new guidelines for preventing similar breaches across the legal profession. 6 months later, I stood in the conference room of my new practice, Blackstone Legal Advocacy, watching the morning sun filter through floor-to-ceiling windows overlooking downtown Fresno. The nameplate on my desk read, Casper Blackstone, Managing Partner. That felt both familiar and entirely new. The transition from our old firm had been smoother than expected. 12 attorneys and 15 support staff had followed me to establish this independent practice. We specialized in consumer protection cases, but with enhanced security protocols that had become our signature. Charlotte Timberlake, my former paralegal and now office manager, knocked on the doorframe. The State Bar Ethics Committee is here for the final security certification review. I nodded. Our firm had become the pilot program for the State Bar's new cybersecurity standards. Every case management system, every client communication portal, every billing database had been designed with multiple authentication layers and audit trails. The committee members spent 3 hours reviewing our protocols. Their final report would determine whether our security framework became the mandatory standard for all California law firms handling sensitive consumer data. Impressive work, Mr. Blackstone, said the lead investigator. Your firm's security measures exceed current requirements by significant margins. We're recommending immediate adoption of your protocols statewide. After they left, I reviewed the morning's case files. 43 active consumer protection matters, each one properly coded and secured. No shadow assignments, no unauthorized access, no mysterious billing discrepancies. My phone buzzed with a text from James Anderson, the trust account investigator who had handled Garrett's case. Saw the news about your state bar certification. Well deserved. Coffee next week? I smiled and typed back, absolutely. The afternoon brought a different kind of satisfaction. I was recording a podcast episode for the California Lawyers Association about identifying internal security threats. The topic had become my specialty, born from painful experience but refined through careful study. The warning signs are always there, I explained to the host. Unusual access patterns, billing irregularities, client complaints that don't match your records. The key is having systems that flag these anomalies immediately, not months later. During the interview, I mentioned our firm's new initiative. I create social campaigns educating lawyers on betrayal patterns, helping practitioners recognize and prevent internal threats before they cause irreparable damage. The podcast would reach thousands of attorneys across the state. If it prevented even one firm from experiencing what we had endured, the effort would be worthwhile. As evening approached, I walked through our offices one final time. The security cameras tracked my movement. The access logs recorded my presence, and the case management system updated my location automatically. These weren't signs of paranoia. They were of lessons learned and wisdom applied. Charlotte was locking her desk drawer when I passed her office. "Good night, Mr. Blackstone. The Morrison case depositions are scheduled for 9 tomorrow. Thank you, Charlotte. Have a good evening." I stood alone in the conference room where this journey had begun 6 months ago. The betrayal that had nearly destroyed our old firm had ultimately created something stronger, more secure, and more purposeful. The city lights of Fresno twinkled below as I gathered my briefcase and headed for the door. Tomorrow would bring new cases, new challenges, and new opportunities to protect consumers from corporate misconduct. But tonight, for the first time in months, I felt completely at peace. Our clients were protected, our systems were secure, and our mission was clear. It was finally over, and the silence felt earned.